Mentioning? Yes.
Lordship, this matter was released by my Lord Justice Arindam Mukherjee. It has been assigned before your Lordship. There's an interim order in this order which is expiring on the 23rd of April. Today is the 21st. If it could be, my Lord, listed tomorrow for extension of interim order.
I beg to appeal, my Lord, for the defendant, one of the defendants in this matter. Lord, instead of tomorrow, my Lord, may it be on Wednesday.
23rd is
When it's expiring.
on the 23rd. On Wednesday it is expiring.
Appear, my Lord, on Wednesday.
Then let it 23rd.
Lordship, I have no issue if, as long as
Lordship, similar matter. The other side.
Oh, the other
there are two interstate suits. This is another suit.
I
also.
don't have instruction to appear in this suit, my Lord. I am not a party. Lord,
Everybody is a party in both the suits.
All right.
You will get briefed by the time it comes up.
I wanted to mention one testamentary suit, Lordship of 2021. I'm praying for inclusion in the list, Lordship.
Your Lordship, may I be permitted to mention one matter for inclusion in the list? There are 3 pending applications. Your Lordship will list the suit along with that.
Testamentary.
Not testamentary. Non-commercial.
Great venture, my Lord. Again, the same parties, my Lord. I am representing the defendant. My Lord, let it be listed, my Lord. Any day we have to seek our direction.
My Lord, may it be taken after Wednesday, my Lord, because there is some difficulties in my family.
Taken now. Yes.
Statement, my Lord.
Inclusion.
What is the listed matters? Item number 1.
Mr. Ghosh, I told you one thing. The vacating application is not before me.
vacating application.
Before my Lord. Vacating application.
Everything is
Well,
before your
well,
Lordship.
it will see that in the vacating application, there was IA2. IA1 was
May I
there,
say one thing, my Lord, subject to my Lordship is today hearing the main injunction.
and there is no need for vacating
Vacating
application because
application is not
we have put in our affidavit.
That
So I'll pass order in this matter.
Vacating, my Lord, no, in
If you
view
agree,
of-
I have no problem.
in view of what has been passed in the order, sir, or in the main application.
Your
no further-
submission is that order may be retained. Your submission obviously would not be that.
Application, there was an order which over time the order was vacated and the matter was to be
No,
reheard.
there's an undertaking content.
But
No,
Whatever that might be.
may I just say, Millet, undertaking Millet, on the last occasion, I had apprised my lord of the situation when the undertaking was given because the matter was to be taken in 2 days' time. Thereafter, Millet, there was a long gap. And then Millets have been hearing the matter.
there has
Because
been-
this, firstly, I have no determination and this is not specially assigned, I think. Only part heard, GA1 is part heard.
Lordship will hear that out. Where is the
With
problem?
regards to GA2, Millet, which was my application, Millet, will kindly have a look at the order passed by. Millet,
Milord, today Milord has
Please,
to
please, Mr. Ghosh.
distinguish his judgment, her judgment.
he will definitely get an opportunity.
Yeah, I'm not getting it.
GA2, the vacating application was not part heard.
No, Millet. GA2 was Millet by an order of Mr. Justice Arindam Mukherjee, Millet. What had happened is that he has recorded. I just read out the order.
It's not a question what the order was there.
But with
GA2
regards to
is-
vacating application, that order.
My point is only the injunction application is part heard. The vacating application is not part heard.
That's the reason why, Millet, may I just clarify? By an order of 10th March 2021, Millet, it has gone in as this. May I just read out the code? This is an application by the plaintiffs inter alia
Take it to-
seeking injunction orders as against the defendant.
Let me have
May I
it.
just hand over the copy, Millet? But this records that now that the injunction is no more there, vacating is not required. And therefore, Millet, I got an opportunity to file my AOAR. And Millet, we have thereafter
I'm
filed our
saying the same thing. I'm saying the same thing. Today, Milord, I am to distinguish a judgments. Whether I do it today, tomorrow, whenever Lordship gives me a chance.
Yes, Millet. I am not standing in the way of that, Millet.
And so far, my undertaking, my point is that if you say that the undertaking is gone, you have to go and apply before Justice Mukherjee and get that. It cannot be in your whims and fancies that matter is not being taken up, so undertaking is not there. Then you should have mentioned that. And I have given judgments to such effect.
Yes, you explain this judgment. Distinguish.
Those judgments were not cited in the court.
Yes, of course I said. What
With
are you
regards to
saying?
undertaking, no,
Yes,
Millet.
absolutely.
not.
My learned
But they
friend
were
has
not
lost it.
cited.
What he was saying?
They were
My
not
learned
cited.
friend,
Millet.
please. Please do
three
not make
judgments.
misstatement. This is a lie to court.
May I just, may I
But
just
this is my-
Yes, Mr. Ghosh, don't be excited.
may I
Let
just-
me have the argument, notes of argument.
I have not been served with the notes of argument, so I do not know
I have
what is
not
there.
served. What are you
Now,
saying?
no, he's not served with
Please,
the notes
please.
of argument.
You have also not served. me, sir.
Not, I am
Yes.
not saying that
I
I
have
have.
served.
Now,
What
let
have
me kindly have a look.
So
at
what
the-
will you distinguish right now?
Well, her judgment.
Yes, my
She's
judgment.
going on and on. There should be a stop to that. Millard,
On
I
and on.
Millard cited Millard. I cited a judgment, Millard, saying Millard undertaking is as good as injunction. And one who breaches the undertaking, Millard, is in contempt. And a contemptor has no right of hearing. That is the judgment. I cited that. Lordship will remember.
No, Millard.
Lordship marks the copies.
Millard.
And we have online recording what is going on.
Yes, definitely online recording
Yes,
is
yes.
there.
Every council should have Millard some responsibility. What she's
Absolutely,
saying.
Millard,
You don't
absolutely.
have.
But I am
But
an
I have
officer
a
of
given
the
note.
court.
Yes.
The judgments that my learned friend had cited, but I have dealt with that in my written notes also. He had
What
cited
is
Millard,
saying? What
Either make your submission or I'll close it.
let her Millard complete
judgments
whatever.
which he has cited.
I had cited
I
Millard
have-
kindly Millard.
Mr. Ghosh, please let her say.
She's saying I have not cited judgment. My notes are there.
That's right. The ones which he
All
has
right, I'm
cited.
reserving it for order.
Can you kindly bear with me for one moment. The ones that he had cited, I have officially dealt with them and distinguished them. Had he cited the one on the basis of undertaking, I would have dealt with it. Since I have not dealt with it, therefore I am not aware of the whatever has gone in his written notes. I have never kind of take my written notes once, only once. Then we'll see the judgments cited by him are at page 9. That he had cited the
Actually,
Chiba
that's the
case.
online touch. You can work on it.
Yes, but he can
Yes,
he
yes.
can take out whatever.
Yes, yes.
I have
These
the Jiva
threats will
case
not.
was- the Jiva case with L at page 9, L was cited by him, K was cited by him. He had shown a judgment with regards to Millard. This one, the memorandum of association not having my name, the codes which I am trying to, that was cited by him. Now, thereafter, Millard, he has also cited Moinuddin, which is paragraph H. Whatever he had cited, I've dealt with.
My friend is saying, Millard, I really don't know.
Mohidin,
Yes, the Moinuddin, Millard will
not Moinuddin, Mohidin.
Mohideen, yes, Millard. Paragraph H was Mohideen, which he had cited.
Yes.
Thereafter, Millard, he had also cited one judgment with regards to memorandum of association, which also Millard was paragraph J, then paragraph K and paragraph L.
Millard, I
Two
have
judgments
cited.
which he has
I
cited.
Mr. Ghosh,
cited-
please.
Kindly Millard takes my notes.
Otherwise, why should I not deal with something which he has cited in court
Yes,
when I've gone to cite all these?
Millard, kindly Millard, do not take this, Millard. I have a written notes on record. I had
Yes,
Millard cited.
must have been
Please,
there.
please,
Mr. Ghosh, this is not argument.
Millard, I had
This is just quarreling.
one
Let,
Millard.
let her submit. Let her finish.
Let her finish, Millard. Well, only if she wants to distinguish now, let her do it. I had cited Millard.
Yes, what do you have to say?
Whatever was cited in court, in my presence, Millard, I have dealt with all of those. Millard, whatever my learned friend is saying today that he had cited, Millard, neither does my note have it, nor had
Which one?
I
Which
don't
one?
know which one is he
Which
asking
one,
talking
Millard? That's
about.
Millard. I will
There
say
are
Millard in
four.
reply. Which one?
But the 4 which were cited by him have been dealt with me in my written notes of arguments.
I had
He
cited.
says that he has cited one more judgment on undertaking. It was not.
Have you got copy of these notes of argument?
No, she has also not
I
given me
was
the
not
copy.
given because
She has
that's
not
what-
given me the copy.
if he wants, I'll definitely give him this.
She has not given me a copy. I have asked for it repeatedly.
No,
Yes, yes, please, Mr. Limit to everything.
I'm reserving it. This cannot go on.
Millard,
Argument is concluded, reserved for order. That's all.
Millard, then Millard have to distinguish his judgments.
But
Millard,
that's all. That's all.
Millard, kindly, Millard.
This is not distinguishing way of distinguishing judgments. This is just a quarreling. You're just quarreling.
I Millard apologize. I take it back, Millard. Whatever way Lordship feels, Lordship do.
Come on the next date with a very short notes of argument. I'm giving you 5 days time. Coming Monday, it is to be filed and I'll reserve it for order.
Yes.
No more time to anyone.
Very well.
Millard, only Millard, the judgments again it will happen. I have not cited it, Millard. Again, Millard, kindly makes a note of it.
All right.
Only-
Then in that
I-
case, I am making 1 month's time. There will be no extension. It will be another 1 month time will be given to for distinction. Go on. Let it go on.
I have Millard. I have to only distinguish her judgments. That was Millard cited on.
Let
the
you
last
do
day.
it.
Millard,
I am allowing it to making distinction one after another distinctions. Do that.
The way Millard Lordship says, I have Millard stopped Millard my submission at least two months ago.
I'm giving you 1 week's time. If you have to come with something with the extra notes of argument, file it on Monday. I'll reserve it. No
May I
further
just-
hearing.
In my Lord's presence, may I just ask Mr. Ghosh to once again officially cite whatever judgments he's given in his report. Such that these
Show this judgment.
But
If you do,
I just indicate before your lordship. Otherwise, that's what it will say.
that is of no use. You give a copy of this
Let her
judgment.
give her notes also. Give her, I am giving it right now. Let her.
The learned counsels shall exchange notes of argument with each other in the meantime, immediately.
And Millard, I have to distinguish her judgments, Millard. 5 judgments she has.
Go on. I can give you more time. Just let this thing go on.
Millard, I don't want that, Millard. Whatever way lordship feels. Kindly gives me I have to only distinguish her judgments. That's all. As a
Another,
counsel, I'm
all right. Monday, she will file another Monday. It will go on. Let this be done. The learned counsels are given liberty to file additional notes of argument. The learned counsel for the defendant is given liberty to file additional notes of argument. In the meantime, notes of arguments shall be exchanged by the parties.
Millard,
The matter will appear in the list on
Monday keeps it, lordship.
28th April.
Millard, only Millard permits me to distinguish the judgments. I have not, Millard. Lordship has told me to stop. I have stopped it immediately. On that day,
Learned counsels are given liberty to file notes of argument.
and Millard,
Additional notes of argument.
Millard, only Millard to distinguish the judgments, Millard.
Whatever you like to. Things will go on, I understand. It will never ending. Or I will release it. Next matter.
Item number 3.
Or we can file a note, Millard, distinguishing the judgment. Whatever.
Given liberty to file notes of argument. Whatever you do, we like to do. I cannot dictate you do this thing or that thing.
Lordship can't. Lordship has told me to stop. I have stopped.
Item number 3.
For the plain statement. There's an issue regarding security of a letters of administration.
Please.
Yes.
Yes.
This matter, my lord, at number 3.
Yes, it will come to the list.
The lordship has, my lord,
So this is in the list today.
yes, my lord, it's in the list. The only question was, my lord, that the final judgment was passed. The only question was about whether your lordship will.
No, there is one correction is to be made. In the report of the learned register, learned assistant registrar, dictionary department, dated 17th April 2025. Corrections may be made in the order dated 10/3/2025 as follow. First, there is a wrong date.
There was a wrong. That was corrected, man.
No, that was not corrected. That's still there. That is to be corrected.
That will be in the page 4, my lord.
25/7/2014.
It will be 24. It will
Yes.
be 2024. Yes.
That is to be corrected. And another personal bond.
My lord, personal bond.
Let this be done.
Only one thing, my lord, may I submit for your lordship's consideration. This matter was finally disposed of without any objection because the sisters, those who were objecting, had withdrawn their caveats. So, my lord, surety is absolute discretion of your lordship. My lord, your lordship can grant it. But, my lord, I'm saying that when there is no contest to this application and the legatees were the mother and the son in the will. So, my lord, surety.
Is there any provision in the rule? It can be
pro-
dispensed with?
Provision is with or without surety according to
With
your lordship's.
surety.
Then only humble request is, my lord, the surety can be reduced because my client, it can be reduced to a, my lord, minimum.
Let the discretion be given to the register. This much. There will be bond shall be furnished. The amount of the bond shall be decided by the register. The court never decides this. Correction date. আমি বলে দিচ্ছি। In the fourth page, the date 25/7/2020 to 25/7/2014 shall be substituted by 25/7/2024. ই লেখো।
This order was already passed. You should corrected the date.
No,
Good.
that is not corrected. There is a prayer of personal executing personal bond.
There was a prayer, my lord, because that time we did not know it would be contested or not. It was contested, thereafter withdrawn. The case
Personal
is-
bond may be furnished in terms of prayer C.
Only one thing I'm praying, my lord, it can be reduced to 10. Usually, my lord, 10% of the asset value, it is more than 10%. 24 lakhs is more than.
When
It's-
there is a prayer, I cannot go beyond your prayer. Why have you written this? You should have amended. The probate shall operate throughout the India, throughout the country, throughout Union of India. Dekho.
Only humble request is, my
Next
lord,
matter.
can it be reduced, my lord, a bit?
Item
No.
number 4.
This is why they made allow this prayer to be remain there. Why did not make you an amendment before passing judgment?
The argument stage, they withdraw their case. That's the
Your Lordship, I'm appearing for the plaintiff. On the last date, Your Lordship was pleased to pass an order that the inspection and discovery of documents be taken up. We've sent notice to the other side. We've not got any reply, Your Lordship. A mail was sent to them on the 14th, and again, a notice was sent on 16th. No one is appearing for the respondent as well.
You are for?
Plaintiff.
Learned counsel for the plaintiff is present. None appears for the defendant. Full stop in terms of order dated 26 March 2025. Direction was given for discovery, inspection, disclosure of documents, as well as admission and denial of documents. Time is extended till 22nd May for the same. Let this be ordered. 22nd May, the suit should appear in the list on 22nd May.
Item 5 and 6.
May it please your lordship. For the petition.
Have I heard it?
Yes, Milord, this is that matter in the partition suit where your lordship had given direction to the joint receivers to file the report. And the erstwhile receiver was supposed to hand over all the papers, which I don't think he has done because the receivers have informed me. Only difficulty is this, I've been informed by one of the receivers that there was a fire in 6 post office. So he could not get the report out because there is no absolutely.
আরে order sheet গুলো দাও না।
It's a blackout there, absolutely. So he could not get out the report, but.
Mr. Ghosh, you are supposed to file a report. Mr. Ghosh, the learned receiver is present in the court today and files a report. What is the date of the report? Dated 21/4/2025. Copies of the report may be handed over to the learned counsels. Full stop. Exception, if any, is to be filed on or before the returnable date. Let the matter appear in the list on 21st May.
My lord will also note that he has not handed over any documents as of yet to the receivers. There was a peremptory direction for 7 days.
Mr. Ghosh submitted that in the course of the day, necessary documents shall be handed over to
Receivers.
newly appointed receivers. To the newly appointed receivers. Full stop. The newly appointed receivers are present today. Let the matter appear in the list on coming Monday for further order in order to assert.
The difficulty is this will be because since there's a direction by your lordship to file the reports by the new receivers, I was told that the electricity would take some time to come in that building.
Only to ascertain whether papers are given or not.
Yes. That can be done on Monday.
Yes.
That can.
The matter will appear in the list on 28th April for further order. Full stop. Exceptions are to be filed on or before the returnable on or before 21st May.
Item number 7.
My lord, in this matter, my lord, I am for the plaintiff, my lord. There was a
Order
talk of,
sheet.
my lord, there was a talk of settlement. Your lordship granted time. My lord, the settlement is in the process, my lord. And she has given me the settlement, terms of settlement. Now, I only pray for some time, my lord, to execute the terms by the parties, my lord. Only, my lord, 10 days. 10 days.
Time is sufficient.
10 days will.
As the talks of settlements are in progress, the learned counsels for the parties seek for accommodation. Let the matter appear in the list on 8th May.
Deeply obliged.
Last order, yes, amicable settlement.
Item 8 and 9.
I am appearing on behalf of the defendant.
And for the petitioner.
The Lordship, we have filed the application pursuant to your Lordship's last order and taking an exception to the special officer's report, your Lordship. I am told that it has already been served upon
It has been
them.
served. It's been
Upon
served.
them. Your
But it
Lordship,
is yet to be listed.
but it has not been listed today.
Which one?
The exception to the special officer's report.
GA number?
It is supposed to be GA 9 if I'm not wrong.
Check
GA
it.
9. GA9 hover.
GA9 of
2025.
as submitted by the learned councils. GA9 of 2025 shall be listed. That will be for hearing only.
That we have filed an application. If my learned friend wants to take any file any opposition or not, we would definitely.
On 24th April.
Very well, Your Lordship.
Let it come, then further order will be passed.
Very well, Your Lordship. I'm ready.
You will know? Shall appear in the list along with the present applications on 24th April.
Item 10.
My lord, may I, my lord, file our affidavit in reply, my lord, in this application, my lord?
GA7?
Yes, Lordship.
What is GA7?
That is, my lord, our application for, my lord, the judgment upon admission, my lord.
Is an application taken out under Order 12, Rule 6, my lord?
May
This is a suit for?
Suit for eviction, my lord. Suit for
You are
eviction.
defendant.
Yes, yes. I am for the plaintiff, Lordship.
I have filed my opposition to this particular application.
My
What
lord,
is admission according to you?
Lord, their claim is that since the partnership, the partners of the partnership firm has changed, therefore there is no existing relation between the original landlord and the partners, and therefore it is liable to be evicted. My lord, my defense taken is that a partnership is a compendium.
Which part of the written statement you are relying upon? As an admission? Where is that?
They are not really relying on any reading in the written statement.
my lord, may my lord, kindly fix another date, my lord, for hearing of this application, Lordship. If your Lordship kindly, my lord, fixed another date, my lord, for hearing, my lord. Miss Arunima Lala Sengupta, my lord, leading us. Miss Arunima Lala Sengupta, my lord, leading us in this matter. If your
Prayer
Lordship,
of the learned affidavit in reply
yes,
filed by the learned counsel for the defendant.
I am for the plaintiff, Lordship.
Plaintiff be kept in record. Full stop. On prayer of the learned counsel for the plaintiff, the matter is hearing is adjourned to 7th May.
It is ready for hearing.
Item 11, 12, and 13.
There is one application by the defendant for it's a demerit application. There are two applications of the
What is
plaintiff.
GA1?
GA1 is the plaintiff's interlocutory application in the suit for injunction. Then there is one more application for
What is
by the
GA3?
plaintiff. GA3 is the defendant's application for demerit. It's a demerit application.
And GA4?
GA4 is plain.
GA3 is demerit application.
GA3 step. If your lordship kindly takes.
Yes.
Takes
Let
up
it be heard, but first. Exchange of affidavit is complete or not? What are the grounds you are stating?
Yes, my lord. Firstly, if your lordship kindly takes a look at the plaint, my lord, which is.
You may mention a paragraph in your application. What is your pleading?
In my application, yes.
Yes.
Firstly, is
That is
the
in GA3.
valuation. Firstly, is the valuation of the suit, which has been enhanced, my lord, beyond the permissible, my lord, beyond the statutory. Because, my lord, it's a. Firstly, my lord, we have taken a point. It's a tenancy which is not covered under the Transfer of Property Act. It's a Premises Tenancy Act tenancy. My lord, the rent is
paragraph.
My lord, paragraph 4. My lord, and the pleading, specific pleading is paragraph 12, if your lordship kindly sees. Paragraphs 11 and 12. So, my lord, first is, my lord, with regard to valuation and the tenancy.
Second is that it will be under West Bengal Premises Tenancy Act
West Bengal Premises
1996.
Tenancy Act, because
97.
yes, my lord, it's the rent, as your lordship would see, it's 7672 per month, and it's
a question of facts.
It's a question of yes, but your lordship would kindly see the valuation which they have computed is on the basis of mean profits. Now, may I draw your lordship's attention to a plaint which is annexed to my application? Kindly comes to page 13 of the application where the plaint is annexed.
Yes, according to you, rent 12 months rent is 92,000.
It would be 92,000. Now they have computed A on the basis that it's a Transfer Property Act tenancy. So by a notice to quit, they have terminated the tenancy. Initially, they had pleaded that it was an expiry of the lease by efflux of time. Subsequently, they had issued another notice. Now, my lord, if your lordship kindly takes a look at their notice, the pleading, kindly takes a look at the plaint which is annexed from page 13 onwards. Kindly takes a look at their pleading and paragraph 8, which is at page 16 of my application. Your lordship is looking for the plaint, my lord.
Page 16 of the application.
Page 16 of the application. That is paragraph 8 of the plaint. May I place it? The plaintiff, by a notice dated 9th October 2018 and further notice written by her advocate dated 4th March 2019, has called upon the defendant to deliver up vacant and peaceful possession of the said property. The notice was issued under section 106. So, my lord, the notice is dated 4th of March, which the plaintiff on its own showing is treating as the 106 notice.
Where in the plaint it is stated that it will be under Premises Tenancy Act?
No, they have not stated.
Then?
They have stated that it's a notice under 106.
Yes.
Yet they have pleaded that the rent is 7672. That pleading your lordship would find at paragraph 3.
Mixed question of law and facts.
No, I am.
Yes, what do you have to say?
I'm not on that point only. I am not on that point only. Even if your lordship takes it as yes, it's 106 notice, then also I say that the valuation could not have been what the plaintiff has computed. Why I say so is from the issuance of the notice, 15 days is when a tenant under the Transfer Property Act would be declared as would be treated as trespasser. So they can compute mean profits from the expiry of the notice period till the date of filing of the suit to get the valuation of the suit. Even that computation brings the valuation to less than rupees 10 lakhs, 6 lakhs odd, the valuation from the date of expiry of the notice period till filing of the suit is 6 lakhs valuation, going by their calculation of mean profits, which is 150 rupees per square foot, which is exorbitantly high, but I cannot at this stage challenge that. Plaintiff is entitled.
Hearing Order 7 Rule 11 application, the court will decide on whether valuation is right or wrong, and specifically whether mean profit should start from this date or that date.
No, I am saying that the mean profit, the date from which the plaintiff
they have made a wrong calculation.
So
they have made,
that makes the
that they have made a wrong calculation.
So they could not have valued the suit at 10 lakhs.
In that case, I'm again saying this is a question of fact. If they cannot prove their case, if something wrong is there, the suit will be dismissed on merit. But it is to be heard on merit. How can I decide at this stage?
I only, if your lordship kindly permits, I'll try and satisfy your lordship only on one point. That even if your lordship takes the plaint case, then also the valuation as per the plaint calculation is incorrect.
All right.
As per
yes.
the plaint. Because
all right, I've got your point. Yes.
1 lakh.
What do you have to say?
Has my learned friend finished?
I want to hear from you.
There are judgments of this honorable court. What the plaintiff in a Order 7, Rule 11, the court has to take the pleadings of in the plaint as sacrosanct. I have pleaded, I have made a valuation, I have made a claim. Whether that claim is right or wrong, whether that claim is maintainable or not, is not a question which can be decided in a demurrer application. That has to be gone into after trial. If I am unable to prove, my claim will be dismissed. But at this stage, my lord, My learned friend, if a plaintiff chooses to make a claim in a plaint, whether that claim is right or wrong has to be decided by way of a trial. It cannot be decided in a demurrer application. At best, it can be a preliminary issue.
No, it cannot be preliminary issue.
At best.
Even it cannot be a preliminary issue.
I bow down to you.
It is linked up to the whole gamut of this case.
Deeply obliged.
I will pass order.
But
Other applications will be heard on the next date.
but only one thing. But I was also carrying judgments to the effect.
Give it.
But could I come back on any other day?
Don't delay this matter.
But my point is very simple.
I understand your point.
But their plaintiff's calculation is for 8,000.
Absolutely wrong.
For 800 square feet.
I am accepting your submission.
150 rupees.
This is absolutely wrong.
But if a lordship calculates that per month, then it's under 10 lakhs.
Right.
So they cannot maintain the
I am
suit
accepting your submission. That is wrong, but that cannot be decided at this stage. The starting point of mean profit, it may be wrongly stated.
Yes.
But
calculation is also, it cannot be more than 10 lakhs. Because they have filed
that's
a
a
suit.
question of fact.
They have filed a suit after 4 months from the date of the notice. So 4 months into 1,20,000 per month is not even 6 lakhs. But they
all right, I have heard you. I'll consider at this point. It আমার চেম্বারে পাঠাবে আমি order লিখব. Next matter.
That your lordship did not look into the judgments which my learned friend and
Show me, give me judgments. Why are you not carrying it today? This is the date of hearing.
relying on certain judgments which
But we are not carrying today. So
Why?
on the last occasion they took time on this ground.
দেখি আগের দিন শুনেছিলাম. Last day possibly I heard it.
They took time. They're enjoying my property.
No, if your lordship kindly keeps it tomorrow, my lord,
Tomorrow, all right.
to delay. I'm kindly keeps it tomorrow.
Heard in part. Fix. April for further hearing.
24th April, your lordship will not do.
28th April for further hearing. Further hearing of GA. GA3 of 24. 2020.
Item 14 to 19.
For appearing for respondent number 1, this application we were to file an
Which application?
GA1, we are to file an affidavit in opposition. May I say one thing? But the problem is, I know I have taken time. The problem is, your lordship knows there is an outbreak of fire in Old Post Office Street. My advocate on records office is in that building. I have not completed, madam.
What is GA1?
Nobody can get into that building. No clients. There's no electricity. Yes, sir. Yes, we are surviving on generator. That too, very difficult. But kindly gives us 2 weeks time. I had a leader.
GA1 is injunction.
Yes, my lord. This was filed in February 2024.
My lord,
Fire has broken out very recently. Mr. Gossip. No,
Next, just a minute. Let me understand the things.
Yes.
GA2.
GA2, 3, 4, and 5 are the applications filed under Order 7, Rule 11 by
Some patience. Let me see it. You will not pass this order.
3 is my application under Order 7, Rule 11.
Dismissal of suit. Who filed this?
One is defendant number 13th
No,
application.
GA2.
GA2 has been filed by me.
Me means?
Respondent number 13.
Who filed injunction application? Plaintiff. Then GA3 is?
Is also my application filed by respondent number 78.
Same application.
Same, Order 7.
Respondent number?
78.
78.
78. There are
90 defendants.
Then 4.
Your Lordship, GA4 is my application under Order 7 Rule 11, filed by defendant number 79.
Defendant number?
79, Your Lords.
76.
4. GA4?
Your Lordship, GA4 is my application, Your Lordship, under Order 7 Rule 11.
Yes, yes. J5?
That is my application. I am for defendant number 76.
Same application.
For dismissal, my different mine is I am for a company. Company's property cannot be partitioned in a suit between the shareholders, assuming they are shareholders.
What is your prayer?
For rejection of plate.
You are?
I'm defendant number 76.
So in all this matter, exchange of affidavit is complete, not yet.
My lord, it is so far as my client is concerned, though the plaintiff has filed their affidavit in opposition in each of the applications.
Replies are to be filed.
My lord, now I come to my lord. Lordship, I had filed my injunction application in the month of February 2024. Then, my lord, when it was moved, my lord Justice Mukherjee, Arindam Mukherjee, released it on personal ground. Thereafter, my lord, the matter was specially assigned to your lordship. Then, my lord, since then, my lord, only 16 of the defendants have used their affidavits in opposition. 16 defendants.
So first the demoner application is taken up. All the demoner application.
My lord, yes. What they have done, my lord, 5 demoner application has been filed on behalf of the 5 companies. 5 companies. To that we have filed our opposition. They have not. They have not filed their reply, my lord. They have kept it pending deliberately, my lord. This is happening on each of the.
So far as reply is concerned in demoner application, is it complete?
Your Lordship, no, it is not complete, Your Lordship. I appear.
So I am giving you a time frame. Finish it.
May I just
because demoner application should be heard first. And for
I
demoner
appear
application,
in
injunction, hearing of injunction application is suffering.
You can fix a short time. We shall
may
make our submissions and we will not repeat each other's submissions. If somebody makes any additional points, others will make. So we shall make it as concise as possible.
So what I understand, your point or common point must be Benami transaction.
Benami transaction, Companies Act, and those series of judgment that the company cannot be implemented in a partition suit.
These two issues are there.
So far as the companies are concerned. So individuals are concerned, I cannot see.
Individuals have not taken out any application. Only
So demoner application, these are all companies.
5 companies. 5 companies, my lord, have taken out. One LLP has taken out on the point that a private limited company has been converted into LLP. My lord, the affidavit in opposition have not been.
Yeah, one is injunction.
Injunction filed in 2024.
Let me pass a timeout order.
My lord, passed
Your
an
Lordship,
order.
I appear in. Your Lordship, I appear.
Inter alia stating that parties continue. But for this reason, the hearing of the injunction application will not be stopped. That was a preemptory direction filed 6 months before by. My lord, what they are doing, my lord, just on the eve of the matter being heard or taken up by your lordship, one affidavit is coming or one application is coming. Deliberately, they are not filing their either pleadings, completing the pleadings, or either the opposition.
Let these
or
4
the
applications be taken up with a very short date. I'm fixing a time frame.
May I just make one submission, my lord?
Right.
Lord, your lordship has.
Not 3 weeks time. I'm giving you 2 weeks time.
My
Your
lord,
Lordship, Your Lordship, am I audible to Your Lordship?
Yes.
may I just make one submission?
Your Lordship, am I audible to Your Lordship?
Lordship will not. Lordship will not. Lordship has stated that.
Giving 2 weeks time.
My lord, I know that. I'm not opposing that. But I'm submitting. The Lordship is of the view now today that Order 7 Rule 11 has to be heard first. These relates to the 5 companies only.
I cannot understand right now because when the demoner applications are concerned, demoner applications are pending. If it is allowed, the whole suit will be dismissed.
No, they have sought for.
That I cannot say right now.
No, their prayer, so far as their prayer is
Prayers
concerned,
that may be.
so, my lord, they cannot.
So if the demoner application is allowed as per the prayer at this point
There
of time,
cannot be an injunction.
There cannot be injunction.
cannot
There
be an
cannot be an
injunction.
injunction against the other defendants.
Lordship, please, I am
Injunction,
submitting.
then cannot be an injunction.
I'm not
Ms.
stopping
Agarwal,
you.
let me fix a date.
Your Lordship,
Milord,
I appear in item number
I
17.
take up
Your
the
Lordship,
order
I
which
also
was
need
passed by
extension
your
of time.
Lordship.
What do you want? Should pass injunction order right
I'm
now?
not saying
Then
so.
forget it.
I am saying, Milord, kindly hear my application as well together. Because the same point will
Cannot
be
be
asked.
done. If the suit is dismissed, then there cannot be an injunction against the defendants.
Affidavit, exchange of affidavit is not complete so far as GA 1 of 24 is concerned. Full stop. GA 1 of 24 is an application for
Milord, these are my replies, Milord. In
ad interim order of injunction. Affidavit in reply shall be, only affidavit in reply is pending. Affidavit in opposition shall be filed within 2 weeks. Affidavit in reply, if any, within 1 week thereafter.
Your Lordship, GA4 is my application. I'm
So far
seeking
as
extension
GA
of time to file reply.
other pending applications are concerned, namely GA 2 of 24, GA 3 of 24, GA 4 of
GA4.
24, and GA 5 of 24, as well as GA 6 of 25. GA 6 is also demoral application. All being demoral applications shall be taken up shortly before hearing of injunction application. Let those matters appear in the list on 8 May. No further time shall be allowed to exchange affidavits. Injunction application MNGA 1 of 24 shall also appear in the list on that date for passing further order.
So my application,
Milord, may I my file
Your Lordship, GA4 is on the ground that
Affidavit in
affidavit in
father
reply
in
and
respect of whom
affidavit.
partition was sought was never a partner of this LLP. So there
Mr.
cannot be any
Banerjee, please.
partition. This cannot be a joint
Affidavit in
family.
reply filed by Ms. Agarwal
And oppositions also to the GAs.
in GA 1 of 24, as well as affidavit in opposition in pending applications be kept in record.
So I was submitting because your Lordship was willing to know on what is the ground for order.
Service in GS6.
This is
GS6 affidavit of service.
affidavit of service in GA 6 of 25 be kept in record.
Your Lordship, instead of 8, can it be 13?
Milord, I am opposing that, Milord. They are then unfriendly. If he is in difficulty, there are other applicants, they will argue. There are other applicants.
Unnecessarily LLP has been made part of the partition.
Milord, there are other applicants, they will argue. If
Let it fix on 8, if you are in difficulty,
partner of
definitely it will be not finished in a
Yes.
single day. Then 13th will be referred.
And Lordship, one thing, we have not received any affidavit in opposition to GA3. She is saying that she has filed her opposition, but
We
in
have filed.
Sub copy.
Milord, it was served, I'll give another copy.
Item number 20.
I believe there's an order on the registrar to file a report. We wanted to amend the affidavit of asset in the probate proceeding. Now the probate has been granted by this court. Now 3 shares of 3 different companies were missed out. So the amendment was sought for on that scope to add those companies.
Report of the landed registry original site dated 21/3/25 be kept in record, and a copy of the report may be handed over to the landed counsel, Mr. Landed Senior Counsel, Mr. Mitro, appearing for the
petitioner.
petitioner.
Petition in the probate proceeding.
Let the matter appear in the list on 8 May.
Milord,
Or how long would you take? Couple of days.
Milord, I don't know about the report.
That's why you have to know it.
Yes, if required, my lord, I may file an affidavit or a supplementary affidavit dealing with
9th April. Fix it 29th April.
29th April. And may liberty be given to me to file a supplementary affidavit if required.
Liberty is also given to file supplementary affidavit to the landed counsel for the petitioner.
And a copy of the report be given to us.
Yes, that direction is given. Otherwise, how can you file affidavit?
21.
My lord, I appear, my lord, for the defense.
I'm appearing on behalf of the plaintiff, your lord.
My lord, to be, my lord, very
Your
candid,
lordship.
my lord, I was suffering, my lord, from fever for a long time, my lord, viral fever. I could not take the inspection.
My lord, I have sent them a notice saying, my lord, I want the inspection
Finish
on
it only
this Wednesday itself, and my lord, it can continue
on
there.
prayer of the
Your
Lord.
Lordship, one more thing, Your Lordship. They have sent a letter, Your Lordship, stating that you give the copies of the documents for which inspection is to be given. Your Lordship, we have given it to them on 4th of December, Your
He
Lordship.
said, can it be submitted? He confessed that he could not do. I'm giving you another chance.
And
You finish it.
they are writing, Your Lordship, that we have to intimate them when we want to give inspection.
they want-
3 days time has to be given to them. They want it on 23rd. They can come on 23rd and give
May I
inspection.
just place this? I said, my lord, on 6 p.m. on 23rd April or any other appropriate day by providing at least 3 days.
Should I fix a date?
Your Lordship will fix a date, Your Lordship.
The inspection of document is yet to be complete. The same shall take place on 28th April.
No, they are saying 23rd, Your Lordship. They will need 2 days time. Your Lordship.
23rd April 2025 at
My lord, at 6 p.m.
At 6 p.m. in default on 28th April at 6 p.m.
Your Lordship, they need to at least
Can
2
it be on
days.
29th instead?
They will
29th
require
April?
at least 2 days time.
Yes, I'm giving.
No,
And
to complete it, Your Lordship.
not totally
pending.
on default, as well as on 29th April 2025 at 6 p.m.
6 p.m. is okay for you?
6 p.m. is fine.
6 p.m. or
Earlier, if they want,
Or-
we don't have any problem.
If possible, mutually
Your
agreed
Lordship,
any time.
it's
or
1,000
at any
documents.
mutually agreed time. Mutually agreed time. Don't quarrel, don't fight.
My lord. But I-
Deeply obliged, Your Lordship. Your Lordship, no other correspondence.